Court, all rise. Hey. All persons having anything to do with fully honorable justice of the appeals court now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning. Good morning and welcome to the appeals court. I am William Meade. To my right is Justice Rubin and to my left Justice Han. We will be the panel on this case, after which we will take a break and the panel will be reconstituted. If you haven't been here before, or if you have been here before, we've read everything. So my best advice is to get right to the point. And with that, I'll call the first case, 24P 187 Commonwealth versus Bolling. Mr. Madison.
Good morning, and may it please the court. Nick Madison for CLAUDE Bolling. No transcript of the trial is available in this case, and the attempted reconstruction produced only an outline of the evidence with significant gaps that's inadequate to address Mr. Bolling's appeal. Due to the inadequacy of the reconstructed record, as well as a constructive deprivation of counsel and ineffective assistance of counsel, a new trial is required in this case. Turning first to the issue with the reconstructed record, when there's a claim that a reconstructed record is inadequate, courts utilize a burden-shifting framework. First, the defendant must come forward with what's called, under federal law, a colorable need for a full transcript. Under state law, it's occasionally referred to as an articulable claim. Once that is raised, the burden shifts to the Commonwealth to establish the sufficiency of the reconstructed record.
Can we just, as far as the record's reconstruction, that was done by you?
Correct, Your Honor.
And you're going to tell us it's inadequate?
Yes, Your Honor. I, on behalf of Mr. Bolling, used our best efforts to assemble as much information about the trial as we can, given the resources available to me, namely Mr. Bolling and trial counsel. Trial counsel affirmed in her affidavit, and again during the evidentiary hearing, that this was the best of her recollection, but there were her recollection of the evidence was incomplete.
And I'll be asking the prosecutor after you. The Commonwealth didn't participate in this.
That's correct.
Or in a different light, they didn't oppose this. You could have put anything you wanted in the record.
Consistent with the obligations under Commonwealth v. Harris of every party to use their best efforts to reconstruct the record, we used our best efforts to reconstruct the record. Trial counsel affirmed in her affidavit and again in her testimony that she included everything that she could remember about the trial in the reconstructed record.
Oh, the thing that trial counsel could not remember was the victim's answer on cross-examination to whether she had a drug problem.
That is the most explicit gap, because that's an explicit gap in the record where she recalls asking the question but does not recall the response. She testified during the hearing that there were objections, she could not remember what they were, and that her recollection, her recall of the content of the testimony was incomplete. She rated it a 6 out of 10.
Do we know anything about why there is no transcript?
In my affidavit that's part of the record appendix in this case, it appears that the FTR recording system, either from FTR's perspective, either wasn't turned on or wasn't working. Everybody seemed to be to assume in the courtroom that it was functioning, but I reached out to FTR, again this is in the record and in my affidavit, and from their perspective it was either not turned on or not functioning at the time. There was simply no recording made of that
What's
tape.
FTR?
Excuse me, Your Honor, I forgive you. I apologize.
You can forgive me also, I'm always...
Slip of the tongue. FTR's For the Record, which is the company that the Commonwealth contracts with to run the recording software, and they're the people who maintain the recordings of transcripts.
And it makes a recording, or is it some kind of mechanism for making a real-time transcript?
To my understanding, it is a recording, and then the recordings are subsequently released to transcriptionists who complete the transcription.
And can I ask you, I have really only one question about this. I'm trying to figure out why the inadequacy here makes a difference. And the reason I ask that is, I assume we could hypothesize the worst-case scenario for the Commonwealth, which would be this question was asked, and in an obviously false way, the witness simply denied any drug use at any time in her life in a way that was obviously false. And that's the answer that she gave. And so then you'd have been able to impeach her with all the evidence of drug use. Let's go even further, evidence that her child had been, I'm not sure that we have this exactly, but let's say we do, that her child had been taken away because of drug use, all of this. Okay. And then we have to conclude that it would have made a difference in the case. And that's the part where I'm sort of having a hard time here.
Certainly, Your Honor. So it's not, I would like to start by pointing out that it's not just limited to that one question and answer, but let me address that one question and answer, and then I'll move on from there. So this case, as the judge found in the decision denying the motion for the new trial, that this was essentially a credibility case between the complainant and Mr. Bolling. If the to use Your Honor's framing, the worst case scenario for the Commonwealth occurred and the complainant flat out denied ever having used illegal drugs, any association with drug use, the trial counsel had completed the investigation to allow her to sufficiently impeach the complainant. Trial counsel would have been able to show that the complainant was essentially perjuring herself on the stand, that she had been incarcerated for
I
drug
just
use.
said that. I said all of that stuff comes in. How do you win the case on that? You're saying, you're hypothesizing that the judge would have then said, every single thing this person says is a lie. So I don't believe that at 2 in the morning the defendant came to her house. And I don't believe that what she describes, any aspect of it, has any relationship to the truth. I just think she's just a big liar who is just coming in here and lying. That's what you're hypothesizing?
No, Your Honor, I wouldn't frame it that way. I would frame it that if she was able to impeach the complainant, as you're suggesting, and had presented the rest of the motive to fabricate evidence, that would have raised, there's a reasonable likelihood that would have raised a reasonable doubt as to the credibility of her allegations, where the only objective evidence that any of the charges occurred was that the complainant had a contusion on her face. Mm-hmm. Otherwise, the judge had to credit her testimony to determine how the contusion...
But you're hypothesizing that this creates a motive to lie.
Yes, Judge.
I see nothing that you've put forward in the record that indicates that her parents were, or sister, whoever it was that actually had control over the child at this time, thought she wasn't taking drugs at the time. You haven't put in anything that indicates that the nature of their caregiving of this child was she can see the child as long as she doesn't take drugs, but one incident of taking drugs and she can't see the child anymore. You haven't put anything like that in. I don't know if those facts might be available in the world, but it doesn't look like you've even tried to get them. And so I'm left thinking, well, I see what that argument might look like, but right now it's speculative. Tell me why I'm wrong.
I respectfully disagree, Your Honor, and I would point to several places in the record. So in the initial petition for guardianship, it notes, sorry, not the petition, the decree of guardianship, it notes that the complainant was unavailable to parent her child, and thus the need for the guardianship, due to being incarcerated. On those dates, if you look at her court records, which are in the record, it shows that at that exact point, she was being held on a probation detainer for positive drug tests. So we have that the initiation of the guardianship occurred.
But this all comes out in the motion for new trial, right?
Yes, Your Honor.
And this was a bench trial.
With one exception, if I may clarify. In the reconstructed record at trial, the complainant was asked about and did testify to unspecified problems with her parents that she was working to repair. That much was in the record at trial.
No, I'm saying this was jury waived.
Correct.
And the motion judge was the trial judge.
Correct.
And she was given all of this evidence that you dug up after the fact, and she said that it would not have made a difference to her.
She did, yes, Judge.
So why isn't that the end of the story?
It isn't the end of the story because the judge, in her order on the motion for the new trial, seemed not to understand how the evidence was going to be offered. She said the fact that the complainant had used drugs or had criminal convictions wouldn't have made a difference. She seemingly understood it as a general credibility attack. The fact that she used drugs, the fact that she had criminal convictions wouldn't have made a difference in her credibility determination. They would have been relevant for those purposes, but the more important purpose would have been in establishing the motive to fabricate.
Okay, so if I can get back to the motive to lie. You're giving me, there's not much time, so maybe cut to the chase. Is there any evidence in the new trial record or anywhere in the record that indicates what well, I don't know if it's the parents, because I think at the time, I'm pretty sure the sister was had legal guardianship of the child. But in any event, is there any indication how either of these, the parents or the sister, would have reacted to knowing or hearing based on this that, oh, she went out that night and did drugs with someone and got hit?
The evidence in the record that she was attempting to use drugs that night, or trying to...
No, I'm asking about evidence that it would have made a difference to her ability to see her child. Evidence about how these guardians would have reacted if they had known, your hypothesis, she went out and took drugs and was hit there. Let's say that's true. You still have to show for it to be motive to lie that it would have affected her relationship with her child. And that's what I'm not seeing.
Yes, Judge. So we have in the trial transcript that she was testified herself to having problems with her parents. We know from the new trial materials that her family, initially her sister, it transitioned to her parents, and that the initiation of that was due to her drug use. I think it's fair to infer that we know that she had problems, we know that she was using drugs and it was causing her to be involved in the criminal justice system, including having her family step in as guardians for her daughter, that her drug use that they were aware of it, and that that was the reason why the family was in control of the daughter. I think we can similarly infer from that, from the fact that she had problems with her parents, that her family felt the need to step in to protect her daughter, that...
Well, the court ordered that.
Yes, but it was a petition filed by her sister, and her parents eventually stepped in as guardians.
Can you address the constructive denial of counsel?
Yes. So I would point out that the record and the judge's findings showed that the defendant was ordered to sit separately from his counsel during trial, that he attempted to speak to his lawyer throughout, at several points during the trial, and that he was unable to. Given the standards set out in Getters and Perry, no more is necessary to establish a deprivation of counsel, and the judge erred by considering what he was trying to tell his counsel, because once deprivation is established, the court does not consider prejudice. A new trial is required.
Was it simply the distance between where the defendant was seated and where counsel was that was the basis for the constructive denial?
It was a confluence of factors. It was the seating apart. There was also the fact, evidence came in during the new trial hearing, that Mr. Bolling was attempting to speak, backing up a second, that the trial judge had told Mr. Bolling, if you need to speak to your counsel, raise your hand. Mr. Bolling was trying to do that. There was testimony that he was trying to raise his hand. There was also testimony that a court officer was telling him to quiet down while he was doing that. So it was the confluence of the distance, the intervention of the court officer.
The judge didn't make any finding vis-a-vis the court officer, but saying that she didn't see it, but she does discount or discredit the testimony that he was waving his arms trying to get counsel's attention.
She discredited the, may I answer the question?
Yes, please.
She discredited the manner in which one witness testified that he was raising his hands, essentially that he couldn't be waving his hands because his hands were handcuffed in the front. But she didn't, and she actually made findings about what he was trying to tell his lawyer. So she did make a finding that he was, in fact, trying to and unable to speak to his lawyer throughout the bench trial.
So oh, sorry, did you? Structural errors can be waived.
Yes.
And there was no objection, and there was an agreement to this courtroom configuration.
So there's not waiver in this instance because counsel was unaware, trial counsel was unaware through trial that Mr. Bolling was not able to get, to be in communication from her. So she wasn't able to waive that because she wasn't aware of it. She did agree to the seating area, the seating arrangement, but she didn't agree not to have communication with Mr. Bolling. Also, a waiver of the right to counsel must be done in a knowing and intelligent manner by the defendant himself.
Well, I mean, it wasn't a per se waiver of counsel, which would require a colloquy. This was what you've argued yourself as a constructive waiver based on the courtroom blocking.
Yes, I would just say that counsel can't agree on behalf of a client without the client's intelligent and knowing waiver to a deprivation.
Given perhaps a different standard of review, why doesn't it matter that the matter that he was trying to bring to counsel's attention was his belief that the victim was lying and fabricating the story, which is something they had discussed at length and counsel cross-examined on?
Because, assuming for a moment that the content matters of what he was trying to say, it matters because Mr. Bolling was testified at the evidentiary hearing that he didn't have a great memory of what he was trying to bring to clients, to his trial counsel's attention. He, when pressed by the judge, gave one example, and I would suggest that the transcript shows he was speaking kind of in summary form. She was saying things that I knew were not true. And he certainly had told his counsel that the allegations were not true. But I think it's when you read in context of his testimony in context, it shows that he was speaking generally, and we can infer that he had specific points he was trying to address specifically to trial counsel.
Your time is up, but I have a quick question. Is it in the record that your client was handcuffed in open court during the trial?
Yes, Judge. There was testimony at the motion for a new trial hearing that he was handcuffed in front during the bench trial.
Okay.
Thank you.
Thank you.
Ms. Levinson.
Thank you. Good morning. May it please the court, Lori Levinson for the Commonwealth. So the reconstructed record in this case is sufficient for this court to conduct a meaningful review of the defendant's claim of ineffective assistance of counsel.
Why didn't the Commonwealth participate?
Well, it was a different administration than the one that I am currently employed by, and the parties who were involved in this trial are no longer in the district attorney's office, so we really don't know why they didn't participate. But as you noted, what we ended up with was a reconstructed record solely from the defendant's perspective with no objection from the Commonwealth. And so the defendant got to present the record in the
That they could remember.
Excuse me?
That they could remember. There is no recording of this trial
Correct.
saying that they got to do it. They're not allowed to lie in it. They're not allowed to say, oh, I remember horrific things and objections that were wrongly overruled. So why does it matter you didn't participate, right?
Right.
So maybe you know more about what happened. Maybe the judge says, but neither of you participated in it. All we have is this, and it's quite limited.
That's absolutely true, Your Honor. Nevertheless, it is still, what you do have before you is still sufficient for you to conduct a meaningful review of the ineffective assistance of counsel claim. I mean, even the questions that have come from the bench this morning indicate that you have a sufficient basis to consider the claim of ineffective assistance of counsel, and there is enough in the reconstructed record for you to consider the claim. Basically, what it came down to is the reconstructed record did not reflect particularly one question, and that is the question about the complaining witness's drug use. And as the motion judge, the motion for a new trial judge, who was the trial judge, found that even had evidence of the complaining witness's drug use, the poor relationship with her family, been more fully developed, it would not have made a difference in her view of the evidence. So I think before you, the question based on the reconstructed record is whether defense counsel was ineffective for not conducting a more thorough review of the complaining witness's background. You can determine on the record that you have whether or not her failure to thoroughly investigate the complaining witness's background was in fact ineffective assistance of counsel. We argue it wasn't because clearly she had enough information to use at trial to raise questions about drug use. Yes, we don't know the answer, but the question was raised. And we also know from the trial judge, motion judge, that she considered that fact that she knew that the complaining witness had an issue with her family and with her daughter, and there was an issue with drug use, and that would not have made a difference in her decision.
She says she knows through cross-examination, so it seems that she knows the answer to the question that wasn't reconstructed.
That's what it seems like, Your Honor. And of course, we also know from the record that the trial judge reviewed the proposed statement of proceedings presented by the defendant.
And didn't change them to put in that she'd answered a question a certain way. So what she says at the hearing is arguably not really relevant to what happened.
Well, respectfully, Your Honor, I'm not sure that it's not relevant to what happened.
I'm not sure either, but it's not part of the reconstructed record.
That is true. It is not part of the reconstructed record, but it is part of the trial judge's memory of what occurred at that trial.
Maybe it is. When given an opportunity to reconstruct the record, she didn't put it down, only when the conviction was challenged. So I don't know. Also, they weren't able to contest it because it was announced in the written document at the end of the proceeding, not at the outset in some way that would have given them the opportunity to question the accuracy of that memory.
What is interesting in this case, though, is that the trial judge made a credibility determination based upon the evidence that was presented at trial, and she found the complaining witness not credible on
some points.
on some points, and found her credible on other points, which shows that there was sufficient evidence before the court to make a credibility determination.
Could you speak about some things, and there were other things that were not cross-examined on because the lawyer didn't know anything about them. Let's move to the question of constructive denial of the right to counsel, if you would.
Well, in this case, there was not a blanket prohibition by the court preventing the defendant from having communication with counsel and vice versa, which has been the case in most of the cases decided by this court in the Supreme Judicial Court when there was a real bar to communication with counsel. Here, there was no bar to communication with counsel, and the defendant could have consulted with each other.
Do you agree that if a court officer were to silence someone trying to approach or make contact with their lawyer, that would be a real bar to them consulting with their lawyer?
It would be a temporary bar, which
Sure, during the trial.
Well, not only during the trial, because in this case, we do have the fact that, like in most trials, even where the defendant is sitting right next to counsel, after counsel is done with her cross-examination or a direct examination of a witness, it is usual that counsel will lean over to the defendant, walk over to the defendant. The defendant may lean over to counsel and have a brief conversation.
Sure, and if a court officer stopped them from doing that, that would be a denial of the right to counsel, don't you think?
But then the defense counsel called the defendant to testify. The defendant had to get up from his seat and walk to the witness stand.
That was later.
But the defendant had every opportunity at that point to say to the judge or say to counsel, hey,
How would a criminal defendant know they're allowed to even do that? They were told to be quiet. Maybe they were told to be quiet by a court officer.
But the judge at the beginning of the trial specifically told the defendant that he could
Raise your hand. Yeah. Of course, his hands were cuffed together. Show me what you think that would look like. Well, I'll show you. So he has to do this. Is that right?
That is right.
Does that sound adequate to you?
Yes.
It does.
Well, that sounds adequate. I mean, that's enough to get attention.
And if it doesn't get the person's attention, a court officer comes over when you try to do it and tells you to quiet down, that doesn't change anything?
Well, defendant could have said to the court
Well,
officer.
yes, but he was told what to do, and then the court officer may have prevented him from doing that. I don't know exactly, because I don't see a finding by the court officer, but maybe you're conceding that the testimony about the court officer is accurate.
I am conceding that the testimony that the court officer spoke to the defendant is accurate because the defendant.
And told him to quiet down.
Told him to.
Quiet down, I think, is the phrase. I mean, I'll look again.
Okay, I don't know the exact phrase, but I do concede that the court officer did have some contact with the defendant, but then the defendant.
When he was trying to get the attention of his lawyer.
And also, we had a very experienced second seat lawyer who testified at the motion for a new hearing that she saw the defendant trying to get counsel's attention, and yet she did nothing.
She's in the audience somewhere?
Excuse me?
She was in the audience?
She was sitting in the well, I believe the
But
testimony was.
not a counsel table?
Not a counsel table, but she was
So
sitting.
she's not really second counsel. She's the supervisor of the lawyer, and she was not sitting at counsel
She
table.
was not sitting at counsel table.
So her job is to jump up in the middle of the court hearing.
She certainly had every opportunity,
To jump up in the middle of the court hearing?
well, to not interject herself, but
Okay.
to walk over to defense counsel.
She can do that?
Sure.
Has she made an appearance in the case?
I don't think that's part of the record, whether,
Well, I'm sure it's part of the record, but, right, I mean, who made the appearance on the docket sheet?
I don't know if
Right,
her
I can check.
appearance was on the docket sheet, Your Honor.
Well, was there evidence that or did the judge make a finding that the defendant was animated throughout the trial or at times during the trial? what was, relative to when the intervention by the court officer, if there was, that happened? Is
I
there
don't
anything that
think
indicates
that was part of her finding. It was just that she noted that the defendant was very animated during the trial. But I don't think her findings included the portions during which he was animated. But I think it's fair for us all to glean from the record that does exist that he was the most animated during the testimony of the complaining witness. Because I think the only other witness was a police officer, and I don't believe there was anything in the record to show that he was being animated during the police officer's testimony. So there are many cases that have been decided by this court, the Supreme Judicial Court, that have held that a defendant was not constructively denied assistance of counsel by various measures taken by courts, whether it be Zoom, whether it be not providing an interpreter, asking the questions be reduced to writing where a defendant couldn't write, which absolutely chilled the defendant's ability to be able to consult with counsel. But we didn't have that kind of chill in this case. And as the hearing judge, motion judge, trial judge found, the defendant could have, and defense counsel could have, opted to speak to each other during the course of the trial, and they simply did not, even despite the court officers telling him to quiet down. As the hearing judge noted during the hearing on the motion for a new trial, the defendant became so animated that he jumped out of his chair, turning the chair over. So this was a defendant who was more than capable of doing some act to try to get counsel's attention, even with the court officer asking him to quiet down.
Given that counsel wasn't informed of this till after the verdict, was this raised at the first possible time the lawyer could have raised it?
No, Your Honor. The first possible time it could have been raised was when the judge announced the seating arrangement, which counsel...
No. The objection doesn't seem to be to the seating arrangement. It seems to be to what actually happened during the trial.
I'm not sure that that is the allegation. I mean, I think the allegation that the defendant has made is that the seating arrangement, the COVID protocols are what interfered with...
But he wouldn't have necessarily known that would happen. I mean, I'm looking at this table here. I don't know how much 6 or 10 feet away is, but it's in parallel according to the drawing, and it may seem fine at the outset of the trial. Yeah, that should work great. And it goes on, and then you find out after trial, in fact, it didn't work. The person was trying to contact you, and you didn't notice. And the court officer was telling them to quiet down. So when would be the first time you could raise that?
I suppose Your Honor is correct that the first time defense counsel became aware of that was after the verdict when...
And therefore a motion for new trial would be the first time you could raise it? Or on appeal, I suppose.
It could be, although, again, defense counsel could have and should have objected to the configuration of the courtroom prior to the beginning of the trial.
Really? Did the Commonwealth object?
The Commonwealth did not object.
So the Commonwealth must have thought it would be okay too, right? You don't want to have a whole trial and then an appeal and maybe have to have a new trial.
The Commonwealth thought it was all right, and it turned out to be all right because in reality, the defendant wasn't really that much further away from counsel than he would have been in a normal courtroom setting. The courtroom at issue, and there's a diagram of it in the record, places defense counsel several feet away from the defendant during any examination of witnesses. So it's really not that much difference. It was a matter of a few feet, maybe 4 feet difference than it would be under any normal trial circumstances. And lastly, I just would like to raise something that defense counsel didn't raise during this argument, and that is the existence of two separate records in this consolidated appeal. There is one record apparently for the direct appeal, which consists only of the proposed statement of proceedings or the adopted statement of proceedings for the direct appeal, as opposed to the transcript of the motion for a new trial, as well as the judge's decision on the motion for a new trial, which makes up the record for your review of the judge's denial of the defendant's motion for a new trial. And this existence of two separate records, I know the defendant argued in his appellate brief, even more forcefully in his reply brief, that the judge in denying the motion for a new trial relied on evidence that was not was not part of the original reconstructed record, and therefore you cannot rely on the reconstructed record plus the judge's findings and the transcript at the motion for new trial in reviewing this appeal. And our position is that the entire record is clearly before this court on this appeal, and that there should be nothing preventing you from reviewing the entire record that is before you, especially since it was the defendant who asked that these appeals be consolidated. And therefore, the record as it stands consists of the entirety of the record, which is the proposed statement of proceedings, the adopted reconstructed record, the transcript of the hearing for a motion for a new trial, and the court below's decision on the motion for a new trial.
I think we understand.
Thank you.
All right. We'll take a short recess.
All rise.